All right, good morning, everyone. I'm Judge Epperson. We're here for arraignments today. I want to take a moment and explain the purpose of the hearing, and then we'll get started. An arraignment is an official proceeding in a criminal case which has two primary purposes. The first purpose is for the court to advise you of the criminal charges that may have been filed against you by the state of Florida. The second purpose is for you to advise the court how you wish to plea, whether you wish to enter a plea of guilty, a plea of not guilty, or a plea of no contest. Before making that decision, you should understand the legal rights that you have in court. Under the law, you're presumed innocent. You have the right to a jury trial, where the state of Florida would have the burden of proving your guilt beyond all reasonable doubt to a unanimous jury. You also have the right to a lawyer, and if you cannot afford to hire your own attorney, then the court can appoint the public defender to represent you if you qualify. You also have the right to remain silent today in court other than telling me how you wish to plea. We're in county court today. That means all cases docketed are misdemeanors. There's two types differentiated by the maximum sentence under the law. First-degree misdemeanors are punishable by a maximum sentence of 1 year in jail and a $1,000 fine. Second-degree misdemeanors are punishable by a maximum sentence of 60 days in jail and a $500 fine. Court costs are imposed in all cases in which you plead guilty, or if you're found guilty, court costs range anywhere from a low of $268 to a high of $625. When I call your name this morning, just come directly to the podium and we'll hold your arraignment. All right, now if you plead not guilty, I'm going to set your case for pretrial conference a few weeks down the road and give you time to prepare for trial or talk further with the state about a resolution. If you enter a plea of guilty, I'll impose some type of sentence today, and your case will be finished today except for carrying out whatever sentence is imposed. With that, we'll get started. Come forward when I call your name. Christopher Abad.
Jake Black on behalf of Mr. Abad. I have information that he's in Orange County Jail.
All right. Can corrections advise? He's on my docket, but he's not there.
No, sir, he's not.
Okay, and Mr. Black, for the Public Defender's Office, your information is rooted in?
The attorney informed me yesterday.
Okay. And why don't we have the parties put their names on the record from the State Attorney's Office?
Riley Janigian on behalf of the state.
Public Defender.
Jake Black for defense.
And I see also we have an Assistant Public Defender there.
Yes, Your Honor.
Sure.
Evelyn Jimenez on the behalf of the Public Defenders, Jerry Reed on behalf of the Public Defenders, and Mary Jane Cooper also on behalf of the Public Defenders.
Oh, okay. So Mr. Black won the draw, huh? Let's see. Okay, yes, Mr. Abad is in the Orange County Jail, so what we'll need to do is reset him for jail arraignment, I'd say a couple of weeks out, and state if you could provide a transport order.
Yes, Your Honor.
Thank you. That's fine. Alexis Anderson.
And what date was that for? I'm sorry. June 25th. Thank you.
Hello, Ms. Anderson. Your date of birth?
January 19th, 1999.
All right, Ms. Anderson, you've been accused of trespassing in a structure. Just one moment while I take a look at the information. Charging document. Okay, the allegation is trespass in an occupied structure, specifically the Uno Boutique Hotel on East Orlo Bronson Memorial Highway. The offense date January 22nd. Because the allegation includes an allegation of occupancy, it's a first-degree misdemeanor. Who is on behalf of, actually, Ms. Anderson, can you afford to hire your own lawyer? I can't hear you.
I have a conflict attorney. Matthew Brockshield.
Who?
Matthew Brockshield.
Okay, that's probably in 19 CF 801.
Yes, Your Honor, that's the case that Mr. Shields is appointed.
Okay, I'm going to go ahead and, if you'd like, I'll appoint that office to represent you in this matter as well.
Please.
I'll appoint the Office of Regional Conflict Counsel to represent the defendant in this matter. Your attorney is not here. Would you like to enter a plea of not guilty?
Yes, sir.
A not guilty plea is entered. This case is set for pretrial conference on the following date and time.
July the 15th?
That's your,
8:15.
that's your next court date.
Okay, thank you.
Thank you. I'm going to stick with arraignments for now. Idris Ben Hockham? Ben Hockham?
Jake Black on behalf of Miss Ben Hackham,
Mr., yes.
in case 20MM438.
All right, sir, if you could state your name and date of birth.
Idris bin Hashim, April 18, 1978.
All right, Mr. Ben Hashem, you've been accused of violation of a domestic violence injunction for protection. It's a first-degree misdemeanor. Mr. Black?
Yes, Your Honor, my client would like to enter a plea of not guilty.
A not guilty plea is entered. Case is set for pretrial conference on the following date and time.
July the 6th at 1:30.
Thank you. Oops, sorry. Turn that down. Eddie Houston.
Jake Black on behalf of Mr. Houston in case 20CT1325. My client would like to waive arraignment and enter a not guilty plea at this time.
All right, that's 2020 CT 1325, no valid DL. Not guilty plea is entered on your behalf, Mr. Houston. Just 1 second. All right, was it, just for the record, was the plea offer extended?
Yes, Your Honor.
Yes, Your Honor.
Was it a time served?
Yes, Your Honor.
He's got some other issues then?
Yes, Your Honor.
Okay, Mr. Houston, we'll give you your next court date in this case as follows.
Pretrial set for July 21st.
All right, thank you. And the only reason I was asking was to see if it might be resolved by a plea to the court, but it sounds like Mr. Black is giving you sound advice and not guilty plea has been entered. All right, thank you. Gabriel Irizarry Quadrado.
Jake Black on behalf of Mr. Izira Quadrado in cases 16CT1350 and 16CT1351.
All right, Mr. Irizarry, your date of birth?
July 1695.
All right, there's two violations of probation, one for operating an unregistered motor vehicle, the other for operating a motorcycle without the required endorsement. Just one moment. Mr. Black?
Yes, Your Honor. My client would like to admit the violation pursuant to an agreement with the state to revoke and terminate credit time served and court costs in case 16CT1350. And as case 161351, my client would like to admit the violation with an agreement with the state to revoke and terminate credit for time served court costs.
That the state's understanding of the agreement?
Yes, Your Honor.
Okay, just one moment. All right, Mr. Irizarry Quadrado, if you agree, and this is the plea that you'd like to enter on each case, please raise your right hand to be sworn.
Do you solemnly swear affirm that the testimony you shall give to be the truth, whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can put your hand down just one moment. Okay, turning first of all to 16 CT 1350. This is the no registration violation of probation. Have you signed a plea form in each of these cases?
Yes, Your Honor, so admissions forms have been signed.
Okay, I need the defendant to answer my questions. Sir, if you could please step a little closer to the microphone there, and let's make sure the microphone's turned on.
Yes.
Did you sign the plea forms for each case?
Yes, Your Honor.
Before doing so, did you read them and understand them?
Yes, Your Honor.
Did you have a sufficient chance to talk to your lawyer about these decisions?
Yes, Your Honor.
Do you understand that in each case, by admitting the violations of probation, that you're giving up your right to have a hearing where the state would have to prove you willfully violated?
Yes, Your Honor.
And turning to 161350, you were placed on probation for operating unregistered motor vehicle. Do you admit that you willfully violated your probation by failing to provide proof of a registration, failing to complete community service hours, and failing to pay your court costs?
Yes, Your Honor.
I accept your admission to the violation of probation, adjudicate you guilty, sentenced to 6 days in the Osceola County Jail with credit for the 6 days that you've already served. There are back costs of supervision. Just a moment. Actually, there's none listed. So there's outstanding fines and costs in the amount of $532.50. That must be paid through the Collections Court program. I'm ordering that you report to the Osceola County Clerk of Court Collections Department on the second floor of the courthouse within 10 days of your release from custody. If you don't show up, you'd be in violation of your sentence, which could subject you to contempt. So make sure you show up within 10 days for the purpose of making a monthly payment plan for this obligation. Your probation, just a moment, Madam Clerk.
He has a D6 on this case.
Your probation in this case is terminated, so the case is closed. I'll lift the D6 suspension that was entered as well. All right, turning next to 16 CT 1351. Just a moment. You were placed on probation for operating a motorcycle without the endorsement. Do you admit that you willfully violated your probation in the following respects? One moment. That you failed to complete your community service hours, failed to show proof of completing required class for driver's license, failed to pay fines and court costs, and failed to pay cost of supervision. Do you admit these things?
Yes, Your Honor.
I accept your admission to the violation of probation, adjudicate you guilty, sentence to 6 days in the Osceola County Jail with credit for the 6 days you've already served. You owe $90 back cost of supervision. I'm ordering that you pay $90 to Osceola County Corrections within 90 days from today's date. There's also unpaid fines of $482.50 and a $50 cost for the services of the Public Defender's Office, so the grand total is $532.50. Again, you must report to the Clerk of Courts Collections Department within 10 days for the purpose of making a monthly payment plan for this obligation. Failure to report could result in additional sanction. Your probation is revoked and terminated. You have 30 days to appeal. I'll lift the D6 suspension in this case as well. There is a $50 cost for the public defender in the prior case, so the total actually is $582.50. All right, Mr. Irizarry Quadrado, you'll be released on these cases today, subject to any other holds that you might have. Did you fully understand everything?
Yes, Your Honor.
All right, it'll all be on paper for you. Thank you. Michael Jackson.
Jake Black on behalf of Mr. Jackson in case 20MM1289. I've been informed that this defendant qualified for level 1 drug diversion and has completed it in the jail and has sent documentation to Lizette. Is that true? She got it?
Yes, Your Honor. Carly Janicki on behalf of the state, I did receive the certificate of completion. I did file a paper form of a null pros, but I can announce it now. State announces a null pros.
Mr. Jackson, did you hear that?
Yes, sir.
The state has dropped the charges against you in this case. This case is closed. You'll be released on this case today, subject to any other holds.
Well, yes, thank you, sir.
Thank you. Jose LaBoy. Good morning. Mr. LaBoy, you've been charged with trespassing in 2020 MM 668. Can you afford to hire your own attorney?
No.
Has the defendant have you filled out an application for the public defender's office?
Yeah,
Your Honor, we've been previously withdrawn from this case.
Okay. Can you afford to hire your own lawyer? You said no?
no,
Do you want me to appoint an attorney to represent you?
sure.
Are you in the system
I'm
for this case?
starting to, yeah.
Okay, because I guess the RCC also conflicted on.
Okay, all right, just a minute. Before I go further, it looks like the RCC, Regional Conflict Council, is also conflicted off. What was the offer, State, if you had one on this trespassing charge?
It's an adjudication of guilt, credit time served, and court costs.
Okay, the state has offered credit for time served on this case. However, I will appoint an attorney to represent you if that's what you wish. You still want an attorney? I would not be able, yes.
The defendant signed a plea form accepting the offer. I just wanted to inform the court about that.
All right, thank you for that information. Mr. LeBoy, step a little closer to that microphone, please.
Yes.
Okay, was it your desire today to enter a plea of guilty on your own
Yes.
without an attorney?
Yes.
Please raise your right hand to be sworn.
Do you solemnly swear or affirm that the testimony you shall give to be the truth, whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, you can put your hand down. As long as we get the defendants close to the microphone, they can remain masked while they're answering the questions. I don't want to jeopardize anything. All right, Mr. LeBoy, did you sign the plea form in this case?
Yes.
Before doing so, did you read and understand it?
Yes.
Did you have a good chance, well, strike that. You understand that you're giving up your right to have a jury trial.
Yes.
If not a United States citizen, do you understand the plea would subject you to deportation?
Yes.
Under the influence of any drugs, alcohol, or medication today?
No.
Do you wish to enter a plea of guilty to trespassing in an occupied structure?
Yes.
Ms. Janigian, a factual basis?
Yes, Your Honor. On March 9th of 2020, the defendant came into the business of sleep on one of the benches. When he was told to leave, he refused. The police were called and made contact with the defendant. The defendant said he came in to get some rest. He continued to lay his head and body on the bench with no plans of leaving. At that point, law enforcement officers placed him under arrest for trespass. This all happened in Osceola County, Florida.
Right, and you might have said this, and I didn't quite catch it, but I presume that the charge is predicated on a curtilage theory. If you could just address that, because it's trespass in an occupied structure.
Yes, Your Honor.
How it's curtilage?
He entered the business and the chair was at the entrance of the location.
Okay, just a moment. Based on the state's recital of facts, coupled with my own review of the police report, I accept your plea of plea of guilty to the charge of trespassing. I will adjudicate you guilty and sentence you to 19 days in the Osceola County Jail with credit for the 19 days you've already served. I'm also ordering that you not return to the Best Laundromat. That's the name of the business, not an assessment of its quality. Don't return to the Best Laundromat, located at 1308 North John Young Parkway. There's mandatory court costs of $273, and I'll simply order that that be paid through Collections Court. You must report to Osceola County Clerk of Court Collections within 5 days of your release from custody for the purpose of making a monthly payment plan for this obligation. I won't impose the 50 application. Mr. LeBoy, did you understand all of this?
Yes.
All right, you have 30 days to appeal. You'll be released on this case today, subject to any other holds. And don't go back to that location.
Okay.
Thank you. Eric Purcell.
Jake Black on behalf of Mr. Purcell in case 20 CT 1292 and case 20 CT 1293.
All right, Mr. Purcell, good morning. In 2020 1292, you received a citation for reckless driving. In 2020 CT 1293, arising out of the same traffic stop, operating an unregistered motor vehicle. Mr. Black?
Yes, Your Honor. My client would like to enter pleas of not guilty in both cases. Also, we'll handle that first, yeah. Also, he has an open case 808 CT 6327, and we'd ask to be appointed to that case as well.
I will appoint the public defender in case 2008 CT 6327. And next court dates as follows.
Pretrial set for July the 21st.
All right, sir, that's your next court date. Thank you. Just one moment. Angel Valino,
He's in the box, Your Honor.
all right. Mr. Verlino, you received a citation for allegedly leaving the scene of an accident with property damage. The offense date is May 27th of 2020. Public defender's already been appointed in this matter. Who's here on behalf of Mr. Valino? Where did he go? Oh, is he coming up?
He's approaching, Your Honor.
Okay. All right,
He's in the
good.
box.
All right, good morning, Mr. Valino.
Good morning, Mr. Epperson.
All right, Mr. Black, are you here on behalf of Mr. Valino?
I am, however, I would ask APD Jimenez how this client wishes to proceed.
The client wishes to enter a not guilty plea.
All right, a not guilty plea is entered, and this case will be set for pretrial conference on the following date and time.
Pretrial set for July 14th at 2 p.m.
All right, thank you, sir.
What was that? I didn't get any. I didn't.
July 14th, 2 p.m.
So do I have a bond? Can I?
I might have to look in. Does he have a bond, Ms. Jimenez? Do you know?
No, Your Honor, we have no information at the court, at the jail.
All right, just a moment. At first appearance, defendant was given a $1,000 bond by Judge Morgan. So unless that's been revoked, you have a $1,000 bond on this case.
So 10%, sir.
Well, I'll leave that to you and the bondsman.
Your Honor,
Okay.
we will discuss it with the defendant.
All right, thank you.
Thank you for your time, sir.
All right, thank you.
Have a good day.
You too.
You too.
Okay. We did have a few pleas that were docketed. I want to turn to those. Peter Beatty.
Jake Black on behalf of Mr. Beatty in case 20MM372.
And who is, Mr. Black, are you going to handle this?
Yes, Your Honor.
All
My
right.
client would like to enter a plea of no contest to both as charged with an agreement for an adjudication of guilt 150 days.
Okay, and that's concurrent?
Yes, Your Honor.
All right, just a moment. All right, and Ms. Janigian, you concur that's the disposition anticipated?
I have no information about this.
Your Honor, Evelyn Jimenez for the record, it's an adjudication of guilt credit, 150 days in Osceola County Jail and court costs for both counts, concurrent.
Yes, I heard the terms. I was just, I was trying to confirm with the state that that was the offer. I assume you have an email or something?
Yes, Your Honor, we do, but it's in my email.
I'll
and-
check. I'm checking.
Someone forward it to me, please.
All right, I'm going to come back to this in just a moment. Mr. Beatty, if you can have a seat, I'll come back to this. Brian Cano. Case 2020 MM566.
Jake Black on behalf of Mr. Cano in case 20MM566. At this time, my client would like to plead no contest with an agreement for an adjudication of guilt, credit for time served, and court costs.
Mr. Cano, if you agree, please raise your right hand to be sworn.
Do you solemnly swear or affirm that the testimony you shall give to be the truth, whole truth, and nothing but the truth, so help you God?
I do.
All right, I know it's probably a little annoying, but you can speak through your mask. It'll be fine, all right? Mr. Cano, did you sign the plea form in this case?
Yes, sir.
Before doing so, did you read and understand it?
Yes, sir.
Did you have a sufficient opportunity to consult with your lawyer?
I did.
If not a United States citizen, do you understand this plea will subject you to deportation?
Yes, sir.
Are you today under the influence of any drugs, alcohol, or medication?
No, sir.
Has anyone made any promises or threats to coerce this plea?
No, sir.
Understanding these rights and consequences, do you wish to plead no contest to resisting a law enforcement officer without violence?
Yes, sir.
State have a brief factual basis.
Yes, one moment, Your Honor. On February 26th of 2020, at approximately 11 o'clock, law enforcement officers arrived at Crestwood Apartments located at 3121 Crestwood Circle to conduct a normal closing routine of the neighborhood pool and making sure that nobody's left in the areas after hours. While walking on foot near the pool area, law enforcement officer observed Hispanic male subject sitting down on the floor of the hallway between the restrooms and the laundry room. He approached the male subject and noticed him made contact with him and identified him as Brian Cano. After speaking to him, he stated that he had a firearm on him and at some point fled the scene, which ensued a foot pursuit. All this occurred in Osceola County, Florida.
Okay, based on the recital of facts from Ms. Janigian, as well as the affidavit that was submitted in support of an arrest warrant, which also provides additional facts showing a legitimate basis for the detention and the flight, I accept, well, not for the flight, but a legitimate basis for the detention and flight during a pat-down for a firearm, which the defendant acknowledged to having. I accept your plea of no contest, adjudicate you guilty, sentenced to 95 days in the Osceola County Jail with credit for the 95 days that you've already served. There's mandatory court cost of $273 and a $50 cost for the services of the public defender for a total of $323. I'll simply order that you report to the Clerk of Courts Collections Department within 10 days of your release from custody for the purpose of making a monthly payment plan for that obligation. If you don't show up within 10 days, it would violate your sentence and subject you to further sanction. So just make sure you do that. You'll be released on this case today, subject to any other holds that you might have. Again, 30 days to appeal. Thank you.
Thank you, sir.
Okay, the two remaining cases for plea are both violation of domestic violence injunction cases. The next case is Christopher Scott, 19 MM 4150. I only say that because we had a hiccup on the last plea due to, I think, the nature of the charge and another ASA handling it. Are we ready to go forward on Christopher Scott?
No, Your Honor, I have no information.
All right. Was there a plea offer extended on Scott?
Yes, Your Honor. The offer was an adjudication of guilt, credit for time served, court costs, no contact with the alleged victim, and no return. And they were to run concurrent.
Okay.
Anybody have any?
Is there any way we can get in touch with the DV attorney?
I have no idea. I need a second. I have no idea.
I'll give you a second. I mean, if the state has conveyed an offer, then the defendant should be able to accept that offer and enter a plea today. I know we're under different circumstances today, but you don't have the files, obviously, then.
I don't, Your Honor. I wasn't given them, and I didn't get an email from him at all. I didn't see these on the docket either.
These may have been added. I don't know. I know Judge Onsavich added a couple of pleas to the docket, so that makes sense that you may not have received adequate notice.
I promise I prepared adequate.
Right.
Your Honor, in my case, in the Peter Beatty case, the hearing time was confirmed by Mr. Peter Donnelly to the JA, so.
Right, like yesterday afternoon?
I think it was Tuesday.
Because I was asked yesterday if I would take a couple of pleas onto the jail arraignment docket.
Because I have some other cases to include it, but.
Right, but these were for Judge Jonsavich's division, and I said, sure, I'll take them, but that would be predicated upon both parties getting adequate notice so they were prepared to go forward. Obviously, the defense is ready to go forward, but is Mr. Donnelly not in the office today?
No, I don't know how to contact him. May I step out and call?
Yeah, what we'll do, it's 9:30. What we'll do is we're going to take a 10-minute recess, and hopefully we can entertain these pleas in 10 minutes or so if Ms. Janigian's able to just confirm through her colleague the terms of these two cases. All right, we'll be in a 10-minute recess. Thanks. Okay, let's go, we're ready to go, according, the state has had sufficient communications, they're ready to go forward on Scott, Christopher Scott. So if he can come forward, we'll handle that case. 2019 MM 4150.
Jake Black on behalf of Mr. Scott.
Mr. Scott, please raise your right hand to be sworn.
Do you solemnly swear or affirm that the testimony you shall give to be the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Okay, sir, you can put your hand down. Counsel for defense, the anticipated disposition, I think you already stated it's a time served, no contact, no return.
Yes, Your Honor, to run concurrent.
Okay, Mr. Scott, have you signed the plea form in this case?
Yes, I have.
Before doing so, did you read and understand it?
Yes.
Did you have a sufficient opportunity to consult with your lawyer?
Yes.
If not a United States citizen, do you understand the plea will subject you to deportation?
Yes.
Are you today under the influence of any drugs, alcohol, or medication?
No.
All right, you're charged in a two-count information, of course. Count one, violation of domestic violence injunction by going to a frequented location within 500 feet. Count two, violation of a domestic violence injunction by communicating or contacting. Understanding the rights and consequences that we've discussed, do you wish to enter a plea of no contest to both counts?
Yes, sir.
State have a factual basis.
Defense would stipulate to the factual basis for purpose of the plea.
The state would stipulate.
Okay, just a moment. I want to take a look at the facts. One moment. Given the nature of the charge, is the state in a position to speak to whether the victim's been notified?
Yes, Your Honor.
Okay. If you could speak to that.
Yes, I can. There is a note in the system.
Okay, just a moment. Okay, page 2 of my charging affidavit is blank. It has the contact and the location, but I don't see the injunction information. I know you're stipulating, but I just want to see that. Let's see. Yours obviously.
Yes, same thing.
Yeah.
And that agency supplemental report, line 12, doesn't have any, just as charging affidavit. I guess it was a time change.
Okay. So maybe there's a civil case I can find here. Let me ask counsel for defense. You received discovery in this case?
No, actually, Your Honor, there's a motion. Oh, wait, sorry, this is a different case.
Yeah.
I can't speak to that. One moment, Your Honor, I can look it up.
I see a couple.
Yes, Your Honor, we have received discovery.
Okay, and within that discovery, I presume there may be the injunction that was violated?
Let me look at one moment, Your Honor.
Might arise out of 18 DR 269, let's see. Yeah, I'm on it, just a second.
The narrative that I have says that he ran Mr. Scott via FCIC, NCIC, and it showed that there was a no contact order on March 27th served. March 27th,
I'm looking at
2018.
the actual injunction. Okay, thank you. Mr. Scott, I accept your pleas of no contest as to count one, violation of an injunction by going to a frequented location within 500 feet. I will adjudicate you guilty. Sentenced to 186 days in the Osceola County Jail with credit for the 186 days that you've already served. With respect to count two, violation of a domestic violence injunction by communicating or contacting, I accept your plea of no contest. Adjudicate you guilty, sentenced to 186 days in the Osceola County Jail with credit for 186 days. These two counts run concurrent. There are mandatory court costs of $273, a $201 domestic violence surcharge, and a $100 cost for the services of the public defender for a total of $574. I'm ordering that you report to the Osceola County Clerk of Courts Collections Department within 10 days of your release from custody for the purpose of making a monthly payment plan for this obligation, or in the alternative, paying it in full if you're able. If you don't show up within 10 days, it would violate your sentence and subject you to further sanctions, so just make sure you do that. You'll be released on this case today, subject to any other holds that you might have. In addition, I neglected to put on the record, as part of your sentence, you're to have no contact with Ms. Shelley Kathleen Witt, and you're not to return. The state and defense said part of the agreement was that he not return. What's the location he's not to return to? I'm assuming if I go look at the information, that will be it. Just a minute. (5273) Jones Road. So you're not to return to 5273 Jones Road, and you must abide by any injunctions that are in place. Did you fully understand the sentence?
Yes, I do, Your Honor. I have just one question, sir.
Okay.
On my release from Osceola County Jail today, I plan on going to...
Just so the defendant knows, his mic was cut off after he said two.
I don't know if I'm going to be able to make it to the clerk of the court within 10 days for my foot. I'm going into the hospital immediately.
Okay. All right, then what about 30 days?
30 days will work fine. Thank you, Your
All
Honor.
right, so the defendant shall have 30 days to report to Clerk of Court Collections. All right, good luck, sir. Thank you. There'll be a fingerprinting and then, process for release. Okay, I'll either do the Beatty case next, or if we're not ready, there's one matter I can handle here in court. Are we still waiting on Beatty? State?
I'm just confirming that there's been victim contact, Your Honor,
Okay.
since I have no notation of that.
Your Honor, if I may, are we appointed to this case?
Yeah, so at the jail, we have one case left, and that's Mr. Beatty. I think I've finished with everyone else. I'm gonna handle a matter here in court, and then I'll come back to Beatty, and we'll either take the plea or not.
Yes, sir.
All right. So let's go now to Ms. Nicole Dominguez, who is here in the courtroom. All right, good morning. Your date of birth?
January 13, 1999.
Okay, Ms. Dominguez, you were set for court a few days ago, I believe, and you weren't here, and a warrant was issued. That was on June 2nd, 2 days ago, Tuesday. What happened on that day?
I know I was supposed to be in court on the 2nd at 2:30, but earlier that day I had called in because online it said that the court was gonna be reopened on the 8th. So I had called earlier that day and they had told me that apparently the court, my court was canceled. So I was gonna receive another letter with a different court day and a different time.
Okay. I'm going to go ahead and recall the warrant in the case, and we'll handle your case today as we would have on Tuesday. This hearing is called an arraignment. It's simply for the court to tell you the charges and then to find out how you wish to plea. You've been accused by way of a uniform traffic citation with leaving the scene of an accident with property damage. It's a second-degree misdemeanor, which simply means the case is punishable by a maximum sentence of 60 days in jail and a $500 fine if you were found guilty or if you pled guilty. You are presumed innocent under the law. You have the right to a jury trial where the state would have to prove your guilt beyond all reasonable doubt to a unanimous jury. You have the right to a lawyer, and if you can't afford to hire your own attorney, I can appoint the public defender to represent you. You have submitted an application. Having reviewed that application, I will appoint the public defender to represent you. Mr. Black is a lawyer here in the courtroom today from that office. I do have one point of clarification on your application, though it's not dispositive of the appointment. Rental income 850, is that money that you pay or money that you receive?
The 850, oh, that's what I paid.
Okay, so that's not really income. All right, so I'll strike that with your, based on your testimony there. Okay, Mr. Black, do you know how your client wishes to proceed today?
I do not, Your Honor. I need to confer with her.
Okay, I'm going to let you confer with Mr. Black, and I'll come back to your case in just a few minutes.
Thank you.
I just stamped it. I stamped it.
Oh, good. Harold?
See,
Yeah, what happened? I'm good with that. I mean, that's my name.
Because normally everybody's a cow, but yeah.
But, you know, it's funny, just about a month and a half ago, I started seeing that pop up on things. I don't know what happened. I didn't
This was
orchestrate
all-
that.
This is like way in the beginning.
Oh, okay, okay. Yeah, all right. It's okay. I'll be an army leader. I'm good. Yeah.
I don't know if I'll keep dancing, but
I know about it, and you don't want to know about it. Yeah.
well, I looked at the other ones and said, so, I can't get in. So
Yeah.
just the gist of it says something about lazy, and I don't know. I was like, I'm not lazy.
What, lassitude or you mean Lizette? Oh,
Well-
I didn't see that.
Yeah. Well, I couldn't click totally on it for it to pop open because it doesn't let me. It just, you know how it gives you like a synopsis,
Yeah.
and it said lazy. I said, I'm not lazy.
Maybe there's something in the fancy word etymology of the word, but because lazy Lizette, you know. Who knows? I don't know.
That's funny.
Yeah, no.
Did you see the musical artist that popped out?
For who?
My name.
No, I did not. Looks like Mr. Bill. Remember Mr. Bill?
It looks like Mr. Bill. It's when I popped up my name, it says musical artist. He wants to be a Lizette.
Howdy.
Oh, Judge. You're so
Questions
funny.
are yours. At a distance with you're old enough to know who Mr. Bill is? Yeah.
And no, my number is not 24. Because it says her favorite number is 24.
Okay, yes. The state has advised that,
Your Honor?
yes.
Are you the one doing IAs?
No, today Judge Morgan will be doing initial appearances.
Because they're asking at what time it's going to start.
Okay,
Do you
yeah,
have a word?
we'll need to direct that to Judge Morgan's,
Okay.
JA. Thank you. All right, we are ready, the state's ready to go forward on Beatty.
Yes, Judge.
2020 MM 372. Mr. Beatty, please raise your right hand to be sworn.
Do you solemnly swear or affirm that the testimony you shall give to be the truth, whole truth, and nothing but the truth, so help you God?
I do.
All right, you can put your hand down. And Ms. Jimenez, are you handling this matter?
Yes, Your Honor.
All right, and you previously put the terms on the record as time served and court costs?
Yes, Your Honor.
My understanding of the offer is 150 days.
I'm sorry, yes, 150.
That's what I mentioned before.
You did. I misspoke. That was my error. Oh, yeah, 150. Concurrent on each case, and then also, of course, the mandatory court costs. Was there any no contact provision or anything like that?
It's a abide by injunction, Your Honor.
Abide by injunctions? Okay. All right, Mr. Beatty, do you agree with all of that?
I do, Your Honor.
Did you sign the plea form in this case?
I did, Your Honor.
Before doing so, did you read and understand it?
I did, Your Honor.
Did you have a good and sufficient opportunity to talk to your lawyer about this decision?
I did, Your Honor.
Do you understand that if you were not a United States citizen, the plea would subject you to deportation?
I do, Your Honor.
Has anyone made any threats or promises to induce you to enter this plea?
I have not, Your Honor.
All right, just a moment. Understanding these rights and consequences, do you wish to enter a plea of no contest to, first of all, count 1 of the information, which is violation of a domestic violence injunction by communicating or contacting?
I do, Your Honor.
And do you wish to plead no contest to count 2, violation of a domestic violence injunction by communicating or contacting in a separate incident?
I do, Your Honor.
Parties stipulating to a factual basis?
For the purpose of the plea, we are, Your Honor.
The state will stipulate.
Okay, and early this morning, I did read the narrative. I find a sufficient factual basis to accept your pleas of no contest to counts 1 and 2. With respect to count 1, Mr. Beatty, I will adjudicate you guilty and sentence to 150 days in the Osceola County Jail with credit for the 119 days that you've already served. With respect to count 2, accept your plea of no contest, adjudicate you guilty, and sentence to 150 days in the Osceola County Jail with credit for the 119 days that you've already served, counts 1 and 2 to run concurrent. There are court costs in the amount of $273 and a 201 domestic violence surcharge, which comes to $474, and a $100 cost for the services of the public defender, grand total $574. As part of your sentence, you must report to the Clerk of Courts Collections Department within 10 days of your release from custody for the purpose of making a monthly payment plan for this obligation. If you were to fail to report, it would violate your sentence and subject you to further sanctions, so make sure you do that. Also, you must abide by any injunctions that may be in place as part of your sentence. You have 30 days to appeal the judgment and sentence of the court. All of this will be in writing for you, of course. Anything else from the state or defense?
No, Your Honor.
No, Your Honor.
All right, Mr. Beatty will be fingerprinted, and that concludes this matter. Thank you.
Thank you, Your Honor.
I believe we've run the docket. Ms. Jimenez, is that right?
Yes, Your Honor.
All right, thank you for everything. We are in, as far as the jail's concerned, we're finished.
Thank you.
All right, we have one more matter here in court to deal with. Mr. Black, the Dominguez matter.
Yes, Your Honor. Jake Black on behalf of Ms. Dominguez. In case 20 CT 572.
Yes.
My client would like to enter a no contest plea with the anticipated disposition of a withhold of adjudication, $200 fine, and court costs, Your Honor.
Can you just look and see if there's any unpaid fines or costs in there?
No, this is her only case here in Osceola.
Okay, one moment. Okay, Ms. Dominguez, please raise your right hand to be sworn.
Do you solemnly swear or affirm that the testimony you shall give to be the truth, whole truth, and nothing but the truth, so help you God?
Yes.
All right. Ms. Dominguez, did you sign the plea form in this case?
Yes.
Before signing it, did you read and understand it?
Yes.
Did you have a good chance to consult with Mr. Black about this decision?
Yes.
If you were not a United States citizen, do you understand the plea would subject you to deportation?
Yes.
Are you under the influence today of any drugs, alcohol, or medication? Has anyone made any promises or threats in order to persuade you to enter the plea?
No.
Understanding these rights and consequences, do you wish to plead no contest to leaving the scene of an accident with property damage? Did I speak too fast, or are you contemplating your decision?
Wait, I'm confused.
Okay, let me back up a minute. All right, your attorney has indicated that you want to enter a plea of no contest to this charge of leaving the scene of an accident with property damage.
Yes.
Is that what you wish to do?
Yeah.
I didn't.
Yes.
Okay. Do you have any hesitancy in making this decision?
No.
All right, state have a factual basis.
Yes, Your Honor. On February 3rd of 2020, the defendant was involved in a traffic crash where she backed her 2011 Toyota four-door bearing 4 license plate IG39FP into a black Mazda SUV bearing Florida license plate ERXP11. The defendant left the scene of the crash without leaving her information with the driver of the Mazda. The defendant responded to the station and admitted to being the driver of the Mazda. She advised she left the scene because she was afraid of having a confrontation with the driver of the Mazda SUV, who was knocking on her passenger side window. This all occurred in Osceola County, Florida.
All right. Because the narrative on the citation and the recital from the state doesn't specifically reference an amount of damage, is the defense stipulating to a factual basis for purposes of the plea?
Yes, Your Honor, for purpose of the plea.
Right. I do accept the plea of no contest. In your best interest, Ms. Dominguez, I'll withhold adjudication of guilt, impose a fine of $200. Withhold was okay, right?
Oh, yes. That was,
Withhold. All right, $200 fine. When I say okay, I mean it wasn't negotiated in terms of
it was negotiated.
adjudication or anything.
No, it was not. I mean, it was negotiated for a withhold.
Okay, right, and I'm happy to do that. It looks like Ms. Dominguez has a clean driving record here. So I'll withhold adjudication of guilt, a $200 fine plus court costs. Those court costs bring the total fine to a total of $526. There's also a $50 cost for the services of the public defender, so your grand total is $576. Based on your affidavit, your application, I'm going to go ahead and put this in collections court so that you can make a monthly payment on this obligation. So I'm ordering that you report today to the Clerk of Courts Collections Department on the second floor of this building for the purpose of making a monthly payment plan. They can set that plan as low as $25 a month. All right, if you're able to pay it sooner, that's fine, or pay it in one lump sum, that's fine too, but you can make a minimal payment schedule if you wish. There was no arrest in the case, was there? All right. You have 30 days to appeal the judgment and sentence of the court. We'll give you your paperwork in just a moment, and then you can go to the collections department. Thank you.
Yeah.
Okay.
You are here for an initial appearance after detention. The rules of criminal procedure require that you be brought before a judicial officer within 24 hours of your arrest. The purpose of the initial appearance is to have a judge list the charges against you, inform you of certain rights that you have, and to determine the conditions of your release. You should have already received a copy of these charges. The judge will review your paperwork to determine if there was probable cause to arrest you. If the judge finds probable cause, he or she will then determine if you qualify for bond and what the monetary and non-monetary conditions of your bond should be. If the judge does not have enough information to make a probable cause determination for your arrest, the state may be given additional time to amend the paperwork. You should also be aware of the following rights afforded to you by the Constitution. You are not required to say anything at this proceeding. Anything you say can be used against you. You have the right to communicate with counsel, family, or friends, and if necessary, you will be provided a reasonable means to do so. You have the right to counsel. If you have not already retained counsel and cannot afford counsel, the judge will appoint you a public defender. For the purposes of today's initial appearance proceedings, you may be able to briefly speak with a public defender regardless of whether the public defender is appointed for you. In order to have an attorney appointed by the court to represent you, you must be financially eligible, as determined by the court based on financial information you provide. Therefore, if you have not already done so, please complete, to the best of your knowledge, the financial affidavits provided by the correction officers. An application fee for the services of appointed counsel will be assessed. If you do not speak English or Spanish, please let a corrections officer know. When the judge is ready, she or he will begin calling your case by name. Please listen carefully for your name. When called, please approach the microphone as directed by the corrections officers. Thank you.
Usted se encuentra aquí para una audiencia o vista preliminaria, después de haber sido arrestado. Las leyes y estatutos criminales del estado de la Florida requieren que se celebre una vista preliminar ante un oficial judicial dentro de un plazo de 24 horas después de su arresto. El propósito de esta vista preliminar es para que el juez pronuncie los cargos contra usted, para que se les comunique a usted sus derechos procesales y para determinar las condiciones de su libertad o fianza. Ya usted debería haber recibido una copia de estas alegaciones o acusaciones por escrito. Ahora, el juez revisará la documentación en su caso para determinar si existe motivo fundado o causa probable para su arresto y detención. Si el juez determina que existe causa probable o motivo fundado, entonces decidirá si usted califica para que se le otorgue una fianza, tanto como cuáles serían las condiciones monetarias o no monetarias de dicha fianza. Si el juez no posee suficiente información para determinar si existe causa probable o motivo fundado para justificar el arresto, se le concederá a la Fiscalía tiempo adicional para modificar la documentación. También se les avisa que posee los siguientes derechos que se les otorgan por la Constitución. A usted no se le puede obligar a decir nada durante esta vista. Cualquier cosa que diga podrá ser utilizada en su contra como evidencia. Usted tiene el derecho de comunicarse con un abogado, pariente o amigo, y si es necesario, que se les proporcione los medios razonables y disponibles para hacerlo. Usted tiene el derecho a un abogado. Si todavía no ha encontrado o contratado un abogado y no tiene los recursos para hacerlos, entonces el juez le nombrará un defensor público. Para el propósito de la audiencia preliminaria de hoy, se le permitirá hablar brevemente con un abogado de la oficina del defensor público, aun cuando no se le haya nombrado para representarle en todo el caso. Para poder recibir la designación de un abogado, primero debe calificar económicamente según lo determine el juez. Esto será basado en la información financiera que usted proporcione aquí. Por lo tanto, si no lo ha hecho todavía, de la mejor manera posible, por favor, llene el formulario de insolvencia económica que se le ha proporcionado por el oficial de correcciones. Se le impondrá un recargo o costo por los servicios del defensor público. Si usted no habla inglés, por favor, hágale saber al oficial de correcciones. Cuando esté listo, el juez comenzará el proceso llamando a cada una persona y caso por su nombre. Por favor, esté pendiente para pasar adelante cuando escuche su nombre y cuando escuche su nombre, haga el favor de acercarse al micrófono, tal como le indique el oficial de correcciones. Muchas gracias por su atención.
Yes, he's asking for the procedures to be held in Spanish.
Good afternoon, this is a Spanish interpreter.
Okay, and have you previously been sworn?
Yes, I have.
Okay, and for the record, your name would be?
This is Laura Royal, State Certified Interpreter.
Okay. And we are here in case 20 MM 1339 for initial appearance. The defendant is at the jail and so does not have the headset. If you'll please state your name, sir.
Señor, por favor, diga su nombre.
Brandon Rosado.
Brandon Rosado.
Rosado, you arrested on a charge of battery.
Señor Rosado, le detuvieron a usted por una acusación de agresión física.
Your bond is presently set at $0.
En este momento dado no tiene derecho a fianza.
Do we have any prior history on Mr. Rosado?
¿Tenemos antecedentes para el señor Rosado?
The defendant has one prior arrest out of Massachusetts, driving without a valid driver's license. Those charges were dropped. That was back in 2014, and the victim is requesting contact.
I'm sorry, the interpreter only heard half of it.
Okay.
I did not hear after 2015.
And the
Your
victim,
Honor, we will be-
excuse me,
Sorry.
the next comment was the victim is requesting contact.
Thank you. Su señoría sí tiene un antecedente penal que se remonta de Massachusetts por conducir sin licencia válida. Fue desestimada en el 2015 porque la víctima no pudieron tener contacto con la víctima.
All right, then, yes.
Your Honor, I think the translation was not correct. The translation stated that the case from Massachusetts was no pros because the victim, there was no contact with the victim. Is that what was stated?
No, the indication was the victim in this case is requesting contact.
Oh, I'm sorry, Your Honor. I heard not requesting contact. The interpreter will correct her translation. Su señoría, en este caso dado, tiene un antecedente penal que se remonta desde Massachusetts por conducir sin licencia válida. Esa acusación fue desestimada en 2015 porque la víctima solicitó no tener contacto.
Okay.
Hello? Oh.
Thank you. All right, I'm going to set bond in the amount of $100.
Se fija fianza en $100.
That bond will be conditioned upon supervision by pretrial release.
Dicha fianza será con la condición de que tenga libertad supervisada con el programa alternativo al proceso. I'm sorry, Your Honor, there's a lot of background noise.
Yes, Your Honor, may we have a moment? We're good to go, Your Honor.
Se impone fianza de $100 con I'm sorry, Your Honor, could you repeat the condition again?
The bond will be conditioned upon supervision by pretrial release.
La fianza será con la condición de que sea supervisado por el programa de libertad provisional.
It will be a condition that you not have any hostile contact with Juliana Vasquez Quiñones.
La condición será que usted está prohibido tener ningún tipo de contacto hostil con Juliana Quiñones.
You will not possess any weapons or firearms.
Prohibido la tenencia de armas o armas de fuego.
You will not possess or consume any alcoholic beverages or controlled substances without a prescription.
Prohibido la tenencia de bebidas alcohólicas o sustancias reguladas sin tener receta médica.
Your next court date will be
If still in jail, June 11th. If filed, July 17th in courtroom 4A at 9 a.m.
Your Honor,
I'm sorry, could the clerk please repeat that again?
If still in jail, June 11th. If filed, July 17th in courtroom 4A at 9 a.m.
Your Honor, oh,
Si sigue encontrándose en la cárcel, la próxima vista es el 11 de junio. Si está fuera de la cárcel, será el 17 de julio en la sala 4A a las 9 de la mañana.
okay. Yes.
Okay.
my apologies, Your Honor. Can we request a no alcohol condition be removed? There's nothing on the charging affidavit that states that it's alcohol related.
I'm going to order no alcohol. Thank you.
Su señoría, podemos solicitar que la condición de que esté prohibido el consumo de alcohol sea cancelada porque no hay nada en el affidavit que indique que esto fue relacionado al alcohol. Yo voy a mantener esa condición.
Thank you, sir.
Gracias, señor.
Thank you, Madam Interpreter.
You're welcome, Your Honor.
Braulio Arce.
PD approved.
Your Honor, Mr. Arce is not present.
Going on record. All right, good afternoon, everyone. This is Judge Epperson. We're here for initial appearances. And I want to begin by having people put their names on the record from the State Attorney's Office.
Lauren Demers for the state.
And from pretrial release.
Officer Ray Oquendo.
And from the Public Defender's Office.
Marcia Sampson.
All right, and do we have a private counsel matter?
Yes, Your Honor. Jerry Jenkins.
Okay.
On the Lampkin case.
Okay, Mr. Jenkins, I'll address Lampkin now then. Just one moment. Let me pull that up. Rico Lampkin can come forward.
PD approved.
Oh, okay, but that's all right. All right, just one moment. All right, Mr. Lampkin, good afternoon. I'm Judge Epperson. We're here for initial appearances. I know you've seen the video explaining the purpose of this hearing. Private counsel is here on your behalf. Sir, do you want to be heard?
Yes, Your Honor. Mr. Lampkin is charged with 31 counts. 27 of those counts are possession of a counterfeit instrument, which are blank checks from the PC affidavit. From the PC affidavit, it says that the 27 blank checks were in a glove compartment with multiple passengers in the vehicle. I would argue that there was no PC based on
in the head notes, which stand for some generally accepted propositions. All right, if this were an instance in which the defendant was charged, for example, with trafficking in cocaine, and there was 150 grams of cocaine inside a baggie in the glove box, I would find the argument to be not only meritorious but prevailing. In this particular instance, based upon the circumstantial evidence, which also includes the recovery of items underneath the driver's seat where the officer allegedly had seen the defendant rummaging about, was found other items, torn up receipts, along with also directly next to the defendant console, 2 identifications bearing visage of the defendant, but other identifying information from third parties. The court finds that there's sufficient circumstantial evidence on the standard of probable cause that standard is met to infer culpability, notwithstanding the constructive location of the items that are in the glove box. With any other arguments, counsel? I follow your argument. I understand it. I respect it, but I find the circumstantial evidence is sufficient in this case to move it beyond mere proximity.
Judge, I would argue that in a circumstance like this, with there being 27 blank checks, that it's basically the same as having multiple firearms, that it would be a double jeopardy for all of them. I'd ask the court to RR him on all but one of the counts.
Okay, any response, State?
Your Honor, the only thing the state would add is that I believe having each separate check would be a separate charge. Each one has a different routing number. It's not the same. I would argue that it's not the same. And because you can be legally charged with because each separate check is a different criminal offense, that he would be entitled to bond and should have bond on each count.
May I just briefly respond?
Yes.
Judge, there was no, in the charging affidavit, there was no identifying characteristics saying that they were in any way different. It just said 27 blank checks. So there wasn't like numbers 1001 through 1026 or 27 or anything like that.
Okay, criminal history, Mr. Kendo?
Judge, the defendant has history out of the state of Georgia, has an active warrant for a failure to appear on a driver's license suspended. There's no extradition on that. From 2001 to 2019, the defendant has charges of possession of marijuana, forgery, possession of fraudulent documents, failure to appear on an abandonment of a child dependent, and one case out of Okaloosa County here in Florida, voting under the influence. There's a failure to appear on that case. That is all, Judge.
Okay, what's designated as count 1 on the charging affidavit, the court will set or keep at $5,000. That's obtaining property under $20,000. Count 2, the possession of identification of another, the bond will remain $5,000. On count 3, knowingly possessing 4 fewer, the bond will remain $1,000. Then beginning with count 4, and counts 4 through 30 are all under 831.11. But under count 4, I'm going to set the bond at $50,000. The remaining counts will be $100 until count 31, the last count, will remain $2,000, which is the possession of counterfeit ID. Did you get all that, Madam Clerk?
Yes. Let me just verify.
Okay,
First count, 5,000.
correct.
Second count, 5,000. Third count, 1,000. Fourth count, 50,000. Everything after that, 100 until the last one, which is 2,000.
That's exactly correct. I haven't done the math to figure that out. But that's the amount. All right, thank you. Thank you,
Thank
Counsel.
you, Your Honor.
All right. Also, I'm sorry, let me finish. As a condition of release, also, Mr. Lampton, should you make bond, you're to have no contact whatsoever with the alleged, I'll refer to him as the co-defendant. That would be Ibrahim, let's see the full name here, Ramdan, Ibrahim Ramdan Abdullah. You're to have no contact with that individual. Next court date as follows.
Next court date on demand.
All right, thank you.
Thank you, Your Honor. Have a great day.
Roberto Jimenez Rivera.
And Your Honor,
This time I'd like to assert the same probable cause argument that proximity is not enough, but he was not the driver of the vehicle.
Okay, I'm having a hard time hearing you. This has been the case all week. Yeah.
Sorry. This time I would like to assert the same probable cause argument that proximity is not enough, but this time he was not the driver of the vehicle. It's the only substantial change.
Okay, I called up Roberto Jimenez Rivera.
Sorry.
That's okay. That's okay. That was going to be.
I looked at my list as alphabetical.
Okay, I thought it was an interesting argument, but. All right, just a moment. Mr. Jimenez Rivera, you've been picked up on a writ. You have a purge amount of $570. It's a child support related writ. And that is the purge amount. And your next, let's see, this out of Volusia County. So Volusia County will have 72 hours to pick you up on the writ. All right, thank you. Jonathan Olmo Padilla.
He requires a Spanish interpreter.
Okay, we're going to do our interpreter cases this time at the end. Okay, so I'll come back to that. All right, so we can do them all at the same time. Let me go to Terry Torres. Hello, sir. Mr. Torres has been arrested on a warrant out of Polk County on a violation of probation in case CF 18648. Bond is 0. Polk County, being a contiguous county, has 24 hours to pick you up on the warrant. If you're not picked up within 24 hours, then you'll be brought back for initial appearance. Thank you. Roberto Martinez. Mr. Martinez, been picked up on a Polk County warrant underlying charged theft. It's case MM 187742. You do have a bond in the amount of $2,000. That's your bond amount. Polk County being contiguous, 24 hours to pick you up on the warrant. If not, you'll be brought back before the court. Thank you. Kathleen Breaker, public defender appointed. All right, Ms. Breaker, good morning or afternoon. You've been arrested on a warrant for which a court's already determined probable cause. For the following charges: count 1, grand theft, bonds $2,500. Count 2, scheme to defraud, bond is $10,000. Counts 3, fraudulent use of a credit card, bond $500. Count 4, false entry into records of a business entity, bond $500. And count 5, receiving goods obtained by fraudulent use of a credit card, bond $500 for an aggregate amount of $14,000. Also, you're not to return to the premises of the Star Island Resort located at 5000 Avenue of the Stars. And your next court date as follows.
Court date on demand.
You'll receive it. Thank you. Deshaun Brown,
PD approved.
public defender appointed. All right, Mr. Brown, you've been arrested on an outstanding warrant for which probable cause has already been determined. The court did, however, go ahead and review the affidavit that resulted in the issuance of the warrant. Your bond on count 1, attempted felony murder with a firearm, will remain 0. Count 2, armed burglary of a dwelling with a firearm will remain 0, as each of those are punishable by life offenses, and the court finds, based upon even without the hearing, the affidavit supplies that the proof of guilt is evident, the presumption great, based upon the testimony of a designated witness in the affidavit. On count 3, armed burglary of a conveyance, your bond in that case will remain $5,000. You're to have no contact with John Caracciolo, who's the alleged victim. You're not to return to 2789 Autumn Breezeway. Also, you're not to have any contact with Ms. Nicole Horta Rodriguez. You're not to possess any weapons or firearms. There is a matter out of Volusia County. That's another jurisdiction. The court won't take action on that. Your next court date as follows.
Court date on demand.
Thank you. Mary Chelsea Tay Gendos,
PD approved.
public defender appointed. Good afternoon, Ms. Gendos.
Good
Am I saying your name correctly?
Yes, sir.
All right, you've been arrested on a warrant out of Osceola County for an alleged violation of probation. Judge Kirsten has set your bond at 0. It will remain 0 at this time. The underlying charge, leaving the scene of an accident. The next court date as follows.
Next court date, June 11th, in courtroom 4F at 8:45 a.m.
Thank you, sir. Have a good
Thank you. You too. Ibrahim Abdullah,
PD approved.
public defender appointed. Ms. Sampson?
Yes, Your Honor. Just the same argument that proximity is not enough, and just the added fact that he was not the driver of the
Okay. All right, the court finds that there's sufficient circumstantial evidence for the probable cause threshold to be met based on the affidavit contained in the file. With respect to the bond amounts, there are in this particular case, I believe, 33 listed charges. On count 1, the bond will remain $2,000. On count 2, the bond will remain $2,000. On count 3, the bond will be $50,000. On count 4, the bond will be 100, 5, 100, 6, 100, 7, 100, 8, 100, 9, 100, 10, 100, 11, 100, 12, 100, 13, 100, 14, 100, 15, 100, 16, 100, 17, 100, 18, 100, 19, 100, 20, 100, 21, 100, 22, 100, 23, 100, 24, 100, 25, 100, 26, 100, 27, 100, 28, 100, 29, 100. 30, the bond will be $5,000. On 31, the bond will remain $5,000. And on 33, the bond will remain $1,000, and the final count will remain $2,000. All right? And the next court date, also, you're not to have any contact with the other alleged occupant of the vehicle, that individual being Rico Lampkin. No contact whatsoever with Mr. Lampkin. Your next court date as follows.
Next court date on demand.
Thank you. Correct. Thanks. Braulio Arce,
PD approved.
public defender appointed.
Oh, I'm sorry, Your Honor. He's refusing. He's in a medical area. He's signal 20.
Okay, signal 20. Okay, gotcha. And that was the Urban Dictionary.
Sorry, sir.
Okay, I'll go with signal 20. Just a moment. Let's, rather than finding a waiver, I'm going to go ahead and reset this IA for tomorrow and see if he'll appear, and do it that way. All right? I don't want to retain my sticky note. Okay, Justin Barros Pires.
PD approved.
And I do have a probable cause argument on this case.
Okay, just a moment. I actually, yes, anticipated that.
Yes, the argument is that no one actually alleges that he hit anybody. The victim herself says that she was throwing things at him. She never made any allegations that he ever hit her. The 911 caller just stated that she heard them arguing, and the police also didn't witness. So we don't have anyone alleging that he hit anybody.
Okay, stage response.
One moment, Your Honor.
Your Honor, the state would just ask for a 24-hour reset.
And Your Honor, I'm objecting to a reset. We have a fleshed out affidavit where the officer is writing up a report based on what everyone has told him. A reset is not going to, I don't believe it's going to come up with any additional information. He shouldn't be held in jail that extra 24 hours.
Okay, your belief might pan out, but because there are circumstances, first of all, I concur with the defense that there's an insufficient basis for the court today to make a probable cause finding. I'm not going to find probable cause. However, given the very visible injuries that are attested to in the sworn affidavit, coupled with the circumstances that are attributed to the caller, I am going to afford this state 24 hours to supplement the record, and the defendant presently has a no bond. I will, because the initial affidavit does not have a bond, I'll grant a bond in the amount of $5,000 today and be amenable to perhaps lowering that tomorrow, or if no PC is provided, then obviously he'd be ROR'd. But for now, I'm going to go ahead and give him a bond of $5,000. Should you make bond, you're to have no contact with Destiny class. No contact would mean none whatsoever, no third-party communications. And then we'll reset this for tomorrow. If there's no PC tomorrow, the defendant will be released on his own recognizance. All right, thank you.
Next court date on demand. Just in case.
Yeah. Jonathan Centron,
PD approved.
public defender appointed. Hello, sir.
Your Honor, Mr. Centron has indicated that he believes he received paperwork that the domestic violence, that the injunction was dissolved, and so he would like the court to check and see if it is active.
Okay. I'm not going to do any investigative work on the case. I did read in the police report where the alleged, where the other party apparently indicated to the officer, if the report's accurate, that she intended to take that type of action, but perhaps neglected to. That, notwithstanding that, the court does find probable cause for the violation of the injunction based upon the sworn affidavit. Mr. Oquendo, history?
Defendant has history going back to 1994, charges of aggravated battery, 4 counts, 4 separate counts, different counts of domestic battery. One of them is the victim as today. That is all, Judge.
You can address the court if you wish. You have the right to remain silent, but the microphone would need to be turned on if you wanted to address the court.
And Judge, we did see that the injunction was still active.
Okay. Well, people did do some investigative work, and the injunction is still active as of this moment in time. But if... Okay. Pending motion to modify. Did your client want to address the court briefly?
No, Your Honor, I just wanted to say that she did file the motion with the court system. I received the documentation from her that it was dropped from the state attorney as well as her. So that's what I was with my family and my wife.
What was the date the motion was filed? Okay. Is there any entry subsequent to the filing of the motion? No? Okay. Okay, I'm setting bond in the amount of $5,000. You're not to return to 2144 RJ Circle. You're also not to have any contact with Ms. Nahena Nieves. You must abide by all injunctions that are in place. You must not possess any weapons or firearms. I hear what you're saying, sir, but the filing of a motion does not actually dissolve the injunction. That has to be by court order, and I'm not seeing any court order in the court file.
But, Your Honor, there was a motion that I have a documentation from the state attorney as well as her that it was dropped. The motion, it was filed 3 weeks ago. So
Okay.
I actually received that it was all taken care of. My interpretation, I didn't know if there had to be a stamp or court approved, but the documentation did
Okay, well, yeah, I'll let you talk to your lawyer about the infirmities of any defenses that you've just spoken to. But we're going to go ahead and, the case has already been handled for initial appearance and the next court date.
It's still in jail, June 11th. It's filed July 13th in courtroom 5B at 8:30 a.m.
All right, thank you. Michael Jamrock, public defender appointed.
Good afternoon.
Good afternoon, sir. I have reviewed the police report. I do find probable cause for battery. Just a moment. Oh, yes. Any history, Mr. Kendo?
The defendant has history going back to 1997, charges of DUI, aggravated assault with a deadly weapon, domestic battery. He has 5 different cases with domestic battery, the last one coming in 2010. All those cases were dropped, Judge.
Any victim contact?
We were not able to contact the victim today. We found that this victim is not the same as the previous domestic battery.
The defense is asking for no hostile contact based on the seriousness of the allegations.
All right, the bond will be set at $1,000. In the absence of victim contact, I am going to, in an abundance of caution, order that the defendant, as a condition of release, have no contact whatsoever with Ms. Elisa Perlet. Also, you're not to return to 2127 RJ Circle in Kissimmee. You're not to possess or consume any alcoholic beverages, not to go to any bars. Alcoholic beverages would include Captain Morgan. No Captain Morgan. Your next court date as follows.
It's still in jail, June 11th, if out July 8th, in courtroom 4E at 8:15 a.m.
And that would actually be subject to pretrial release supervision as well.
Yes, Judge.
All right. Thank you, sir. I may be mispronouncing the name here. Reese Katwara or Kotwaru.
PD approved, and the victim's outside.
Okay. Hello, sir. Can you please state your name? I want to say it correctly.
Reese Katwaru.
Okay. One moment. The alleged victim is entering the courtroom momentarily. Ms. Singh?
Yes.
Hello, I'm Judge Epperson. Can you please state your name?
Gayatri Singh.
Okay, you are the, you can look to the screen there and you can see Mr. Kotwaru there. You are the named victim in the case, and so you have the right to be heard today, and I'll get to that in just a moment, all right? I have reviewed the police report. Based upon its contents, I do find probable cause for the listed charges. Public Defender's Office is appointed in the matter. Mr. Oquendo is here from pretrial release. Do you have any criminal history?
The defendant has prior arrest in 2016 for a domestic battery. Those charges were dropped. And in 2014, out of the state of New York, a charge of DUI and refused to take a breath test. That is all.
Okay. Ms. Singh, did you want to say something today about this matter?
The one that happened last night?
Yes, ma'am. And if you'd like, it's okay with me if you take that down to speak, yes, so I can hear you clearly.
Before the police officers left, I was trying to alter my statement because I didn't realize that there wasn't a weapon in his hand when he had the baby in his hand. We did find it closer by the stove because we have a kitchen in the garage. So that's where it was.
Okay. Any questions from the state?
Yes, Your Honor. Ms. Singh, were all 4 children home
Yes.
during the incident? And the one that he was holding is 6 months old? And you're saying today that he didn't have a knife, or you found it? I'm confused what you're saying.
He didn't have it in his hand. It wasn't where he was when I was on the phone with the police officer.
All right, and then, but you told the 911 operator that he did have a knife.
I thought he did, yes. It was actually the car key.
It was a car key, okay. And you did make multiple attempts to call 911, right?
No, just one.
But when you first went to try to call 911 is when he grabbed the phone and tried to prevent you?
Well, I was going to record because we were arguing, so I was going to record it, and he thought I was calling 911, but I wasn't yet.
Are you scared of him?
No.
Would you call the police if something happened again?
Yes.
Did you recently, earlier this year, file for an injunction against him?
No. I think he filed.
Filed for an injunction against you?
I think he tried to.
And do you know why?
No. I didn't see anything coming into the mail or anything like that.
No further questions, Your Honor.
Any questions, Ms. Sampson?
Questions?
Okay. All right. Mr. Kitwaru, having found probable cause for the listed offenses, I'm setting your bond on count 1 battery at $500. On the remaining counts, I'm setting bond at $1,000. That's for counts 2 and 3, the ag assault allegations, count 4, the child abuse without great bodily harm, and then the last one for depriving means of communication. Also, should you make bond, it would be supervised by pretrial release. You're to have no contact for now, subject to further modification. You're to have no contact whatsoever with Ms. Gayatri Singh. You must not return to 215 Canterbury Court in Kissimmee. If If you have personal belongings at that location which you need, such as clothing, toothbrush, toiletries, personal items, we grant a one-time return with the assistance of the sheriff's office for acquiring those items. Also, based on the contents of the police report, I'm also ordering that you not possess or consume any alcoholic beverages or go to any bars. You're not to possess any weapons or firearms. Okay, your next court date will now be announced.
Next court date on demand.
Judge, if I may, he doesn't qualify for pretrial release as a charge of child abuse.
Okay? All right. Because of the rules of the pretrial release program, you won't qualify for pretrial release, but you still have to follow all the conditions announced. I'm the Assistant State Attorney present standing.
Yes, Your Honor, I just wanted to clarify, based on the allegation of child abuse, is he allowed to have contact with any of the children, or is Your Honor putting that as part of the no contact order?
Just a moment. There's a six-month-old Jake. The other children in the home,
Yes.
the ages of the other children?
6, 5, and 3.
I'll simply order additionally that Mr. Quatwaru have no unsupervised contact with any of the children, no unsupervised contact. All right, thank you, and court date will be provided. Thank you for being here, Ms. Singh. Mark Lusencourt.
PD approved.
Public defender appointed. Oh, is someone out there? Our deputy disappeared, so maybe he was just escorting her. Okay. All right. This is Mr. Lusencourt. Mr. Kendo, history?
Defendant has history going back to 2007, charges of larceny, 6 total domestic battery charges, separate cases. He was found guilty of domestic battery in 2010 twice, 2014. The last charge of domestic battery coming in 2019, which was dropped. And we're contacting the victim. The victim is requesting non-hostile contact.
Okay, court sets bond at $2,500, finding probable cause for battery on a pregnant individual. The defendant, for now, shall have no contact whatsoever with Ms. Melinda Monique Potts, not to return to the main gate, a roadway main gate located at 5995 West 192. If there's personal belongings such as clothing or toiletries, one-time return with the assistance of the sheriff's office. That could be subject to modification with respect to no contact, but as of now, that's the order. So make sure that you have no contact whatsoever. Your next court date as follows.
Next court date on demand.
Thank you. Khalib Marag.
PD approved.
Public defender appointed. All right, sir. Good.
How you doing, sir?
Good, thank you. I have reviewed the police report. I find probable cause for the 4 listed charges.
And Your Honor, given that there's 2 charges for possession of a weapon, I am asking if the court would be inclined to reduce the bond amount on one of the charges.
Okay, actually, I'd have to take a look. I believe one of them is for possessing ammunition, the other for a firearm, and it's under the same umbrella, but I don't have, just a second. State, do you have your hard copy of a statute book there that would include 790?
Doesn't look like it, Your Honor.
Okay, it's take me 2 seconds here. 790.23. I haven't got it here. Subsection. Okay, yes. The factual basis, there was a bullet allegedly, there was a bullet in the defendant's pocket and a handgun next to him. And the bullet in the pocket was consistent with those in the magazine of the loaded weapon. And so the court is construing the charging affidavit as charging a count for the firearm and a separate count for the bullet. And the statute 790.23, which I'm looking at, both of those allegations would be under subsection 1A, which states it is unlawful for any person to own or have in his or her care, custody, possession, or control any firearm, ammunition, or electronic weapon or device, or to carry a concealed weapon. And maybe you're aware of that. You're just asking me to treat it differently for bond. I don't know. Okay, so moving forward, Mr. Okendo, history?
Defendant has history going back to 2014, charges of attempted homicide, which were dropped, premeditated murder, which was dropped, and the last arrest coming in 2019, burglary to occupied dwelling, those charges were dropped. The defendant qualifies for direct PTR if you choose that, Judge.
Okay. Based on some of the attendant circumstances to these charges, having found probable cause, bond on count 1, which is possession of a firearm by a convicted felon, your bond will be $50,000. Your bond on count 2, possession of drug paraphernalia, will remain $500. Possession of cocaine, $1,000. Possession of ammunition by a convicted felon will remain $4,000. Should you make bond, you're to have no contact whatsoever with the other 2 individuals who were in that car, that being Jonathan Suarez Fonseca, Joshua Rodriguez. Also, you're not to possess or consume or ingest any controlled substances without a prescription. You're not to possess any weapons or firearms. Your next court date as follows.
On demand.
Thank you. Joshua, it was, let's see, is Jonathan Suarez Fonseca, and then Joshua Rodriguez. Thank you.
50, 50, or 15?
50. Yes. Jose Morales Diaz. The mic's off there. I didn't hear you.
PD approved.
PD appointed.
That's also a Spanish interpreter, Matt.
Okay, all right. Eric Purcell. Santase. Had to get that out. Public defender appointed. All right, Mr. Purcell, I have reviewed the police reports, and based upon sufficient circumstantial evidence, the court finds probable cause for the listed charges before determining bond amounts. Mr. Okendo?
Judge, these are added charges. The defendant is arrested on 2 other separate cases, reckless driving and resisting officer with violence. Also has history from 2008, home invasion, burglary of a dwelling, battery, and a charge of robbery, which was dropped. That is all, Judge.
And what was if you have it, what was the disposition on the burglary of a dwelling?
Adjudicated guilty, Judge.
And what was the year?
I believe that was 2009.
Okay. Okay, so we're going to start with case 20 CF 1603. Burglary of a conveyance, count 1 will be $5,000. Count 2 will remain $500 on the theft. Moving to case 20 CF 1604. Count 1 burglary would be $3,500. Counts 2, 3, and 4 will remain $1,000, and the last count of theft will be $500. Moving to 20 CF 1605, the bond on count 1 will be $3,500 for burglary of a conveyance. Count 2, $500 for theft. And then moving, actually that's it, isn't it? All right, Mr. Purcell, public defender's been appointed to represent you in these matters. Just a second. Is this subject to pretrial release supervision?
Does not qualify, Judge.
No. All right, sir, your next court date's as follows.
Next court date for 2020, CF 1603, 1604, and 1605 on demand.
I also neglected to indicate, Mr. Purcell, you're not to return to Gold Dust Circle, all right? You cannot go to that location, Gold Dust Circle. I'm not going to particularize any specific addresses, just that entire street, that whole, okay? All right, thank you. Yes, on all 3 cases, Gold Dust Circle. Mahmoud Radad,
PD approved.
Public Defender appointed. Hello, sir. I have reviewed the police report. I do find probable cause. Mr. Okendo, history?
Defendant has history going back to 2018, charges of petty theft, aggravated stalking, defamation of women, and last arrest coming in 2019, a violation of a no contact order, which was dropped. It is not the same victim as today.
I didn't catch the charge that had the name, something women?
Defamation of women.
Defamation of women. Is that another jurisdiction or?
It doesn't specify.
Okay. All right, Mr. Radad, your bond on this will be $1,000. Should you make bond, you're to have no contact whatsoever with Siham El Sharkaway. I'm probably mispronouncing that. Sharkaway?
Yes, sir.
I'm sorry, El Sharkaway. Yes. No contact whatsoever. You must not return to 2537 Chatham Circle. All right, if you have personal belongings there, such as clothing, toiletries, toothbrush, you may return one time with the assistance of the sheriff's office. Also, you're not to possess or consume any alcoholic beverages or go to any bars. Your next court date as follows.
Next court date is still in jail, June 11th, if filed July 13th, in court 4A and 9:30 a.m.
Thank you. Jonathan Suarez Fonseca.
PD approved.
All right, the public defender is appointed in the matter. Mr. Okendo is here from pretrial release history.
Judge, the only history he has is out on bond on an Osceola County case, 19 CF 4130, charges of stealing and stolen property and fraud. That is all.
All right, court finds probable cause for possession of drug paraphernalia and possession of cocaine, setting bond at $500 in count one, $1,000 in count two, subject to pretrial release supervision.
He does
Well,
not
it does-
qualify, Judge.
yeah,
I'm sorry.
out on
due to
bond.
being out on bond.
I'm sorry about that. All right, Mr. Suarez, also, you're not to possess or consume any or ingest any controlled substances without a prescription. You're not to possess any weapons or firearms. In addition, you must have no contact with Joshua Rodriguez or Khalib Margag, the two individuals who were allegedly in the same vehicle. Based on probable cause for a new felony offense, your bond will be revoked in 19 CF 4130. Your bond will be zero in that case in front of Judge Karsten. Your next court date in this matter as follows.
Next court date on demand.
James Vila,
PD approved.
public defender appointed.
Your Honor, that's the guy from yesterday. He's still in medical detox.
Okay, then we will reset him for tomorrow.
Yes, sir.
Thank you. Okay, we have, I believe, two interpreter cases. We'll go to our interpreter cases next. So what division are you in, Miss Sampson?
I am in Judge Arendis's division now.
Oh, okay, that's right, yeah.
I've only been for like one time though, since the switch. I switched right before quarantine, so.
Icy in here, I love it. properly, anyway. Yes. Well, we'd have to, one of them is a warrant. Let's see, on the other one, I'd probably reset him for tomorrow and keep his bonds the same, because I wasn't going to change them anyways. We're trying to get the interpreter on the line momentarily here. We'll move, hopefully. Let's hope I have time to make a 7-Eleven trip before my 2:30. I knew John was doing a few things today, yeah. You're bilingual, right? You're bilingual, right? And let me, trying to figure if there's another way to do that, but yeah, I wonder if I summon the remote interpreter, whether they could be heard there. Well, I know on one of these two cases, Miss Sampson, on Mr. Olmo Padilla, it's a Polk County warrant, and he has $1,000 bond. I was just going to advise him that Polk has 24 hours to pick him up, or else he'll be coming back to court tomorrow. So that's pretty much all there is to that one. It's not, but do I need to testing with the interpreter? Do I need to hit teleconference? No. I mean, we could even use this, well, speakerphone. Okay. Maybe I shouldn't have pressed it. Okay. All right. Okay, and if you could maximize the use of that microphone, Mr. Oquendo, by putting
Yes,
it,
Judge.
okay. Let me have Mr. Jonathan Olmo Padilla come forward.
Señor Jonathan Olmo Padilla, por favor.
All right, and I will administer an oath, Mr. Oquendo, if you could raise your right hand to be sworn. Mr. Oquendo, do you solemnly swear to translate as faithfully from English to Spanish and Spanish to English to the best of your ability?
I do.
And are you fluent in both English and Spanish?
Yes, I am, Judge.
All right. Can you hear Mr. Oquendo at the jail?
¿Usted me puede escuchar?
Sí, yes.
Yes.
Mr. Olmo Padilla, you've been arrested on a warrant out of Polk County for grand theft.
Señor Olmo Padilla, a usted se le arrestó en una orden de arresto del condado de Polk por hurto mayor.
You do have a bond of $1,000.
Usted tiene una fianza de $1,000.
Polk County has 24 hours to pick you up on this warrant, or else you'll be brought back before the court.
Polk County tiene 24 horas para buscarlo a usted ahí en Osceola, o si no, se le traerá aquí a la corte otra vez.
Thank you.
Gracias.
And then I believe the last case we have is Jose Morales Diaz.
Por favor, José Morales Díaz, se le asigna al defensor público.
Public defenders appointed.
Defensor público está asignado.
This police report neglects to identify the victims by proper name. It rather refers to them as victim 1 and victim 2. Notwithstanding this, it does articulate probable cause for battery, for 2 counts of battery.
Can I translate, Jeff?
Yes.
Este reporte de arresto no menciona a las víctimas por nombre. El juez encuentra que hay causa probable.
Defendant is out on bond on a battery in 2020 MM1319.
Usted está bajo fianza en un caso 2020 MM1319.
This will be interesting. Mr. Oquendo, history?
The defendant has history since 2019, charges of grand theft, no valid driver's license, and the case that he's out on bond, 2020 MM1319, has history out of Pennsylvania, 2012, with charges of assault, reckless endangerment, and terroristic threats, and out of Puerto Rico in 2016 with felony. The underlying charges unknown. There is an active warrant out of Pennsylvania for the failure to appear on terroristic threats.
All right, if you could translate thyself.
El juez pidió historia criminal. Se le dijo que usted tiene historia aquí en la Florida desde el 2019 con cargos de hurto mayor, guiar sin licencia válida y que está bajo fianza en el caso 2020 MM1319. Tiene historia del estado de Pennsylvania con cargos de terroristic threats, que serían haciendo amenazas terrorísticas. Desde Puerto Rico tiene un cargo de una felonía, no se sabe la disposición, y tiene una orden de arresto del estado de Pensilvania con cargos de no aparecerse por las terroristic threats, las amenazas terrorísticas.
Having found probable cause, bond on each count will be $1,000.
El juez ha encontrado causa probable y cada uno de los cargos de hoy tiene una fianza de $1,000.
You're to have no contact with the alleged victims of these batteries.
No va a poder tener contacto con ninguna de las víctimas de este caso.
Bond in case 2020 MM1319 is revoked.
Se le cancela la fianza en el caso 2020 MM1319.
Zero bond on that case.
No hay fianza en ese caso.
Next court date as follows.
Su próxima corte es la siguiente.
Next court date, if still in jail, June 11th. If out, July 14th in courtroom 4E at 8:15 a.m.
What's the time again? Su próxima fecha de corte, si todavía está en la cárcel, va a ser en junio 11, pero si sale de la cárcel va a ser en julio 14 en el 4E de la Corte de Osceola a las 8:15 de la mañana.
Thank you, sir.
Gracias.
I believe we've concluded all of the initial appearances. Yes, sir. All right, thank you, everyone. Thanks.
All right.
Thank you, Mr. Kendo.
Thank you.
Right.